In this presentation, I'm going to give you a overview, and I'm going to call this part one. I'll do another one later on after spring break that gets a little bit more specific into how you're going to use this for your research papers. But I want to provide a general overview first and have you think about using the table of contents. So what I did in this presentation is pulled out the titles from the table of contents and gave you what I'm hoping that you'll look for so that you'll see the language that we're going to use in this class is different than you would use in another class. So the big picture is that these are the rules of the game for federal courts. And so this whole book, right, which you can also find in a variety of sources. I gave it to you on our website as a PDF, but you could also Google it and use the LII by Cornell School of Law that also has has this in kind of more details if you want that. But probably the first thing you need to understand is that states and cities have their own rules. So this is only for the federal courts. I have another video that I'll share with you that gives you a very brief introduction to the levels of courts. But you need to mostly think about when we bring a claim in federal court, there's very particular reasons for doing that. Usually it's because there's a federal law that is being involved or a constitutional principle. So you want to think about it in that sense. These big issues that we're looking at are very likely going to have a federal law that's involved or a constitutional principle. But in some situations, it's better to bring a claim in state or city court. These rules are all about what evidence can be used and what evidence must be thrown out. In other words, what a judge must throw out. So this book is mostly talking about how to bring objections, how to dismiss evidence, and how to appeal a decision about the evidence by a judge. I want you to notice that this is federal legislation, so passed by the United States Congress, both the House of Representatives and the Senate, and then signed into law, and what I would term here as actionable law. So this is a law that you can bring a claim under. So you can say, such and such lawyer violated the rules of evidence, or the judge made an incorrect ruling based on the rules of evidence, and I'd like to bring a lawsuit to try to change that decision. And so in this sense, right, the rules of federal courts are law. So not many of you had thought about law in that sense. You thought about law as an obey kind of command kind of situation. Here you can see this is not about obeying something. This isn't like don't cross the street without looking kind of thing. This is more what we call in this research is called constitutive, right? So this sets up the rules of the game, and that's a form of law as well, something I want you to start to think about more and more, and we'll be referring to that as the institution of law. You'll also see that in the scope and the definitions here, and it's interesting, right? Because it's the very beginning, it's a table of contents, and these first six are things that you might, want to just jot down in your general notes or take a screenshot or just try to remember these things because you'll kind of want to remember these terms throughout the class and then if you move on to other Justice Academy classes. The main thing I want you to know from Rule 102, this is the rulings on evidence. These are evidence is being offered by lawyers to try to make some kind of a claim, to support their proposal, to support their point of view, to support the thing that they want to have happen in the trial. And so what this rule is all about is saying, look, you can appeal a decision that's been made by a judge, but only if the error affects a substantial right. So it has to be something that you already had a right to. So if a judge makes a decision and it didn't really affect your position in the case and a right that you have that's clearly indicated in either the rules or in the Constitution, then you're not going to win that appeal. The second thing that you need to think about here is that lawyers will bring a claim or a challenge to evidence in order to prevent the jury from hearing what would otherwise be inadmissible evidence. So this is the adversarial part of it, right? You've got somebody against another person. So one lawyer is trying to bring the evidence in to prove their claim. The other evidence is trying to say that evidence is inadmissible, meaning that it shouldn't be allowed to be presented as evidence. So one of the first and most likely claims you're going to bring to try to keep evidence from getting in the court is by saying it's not relevant. And so, and I might point something out, right? The bottom, it says irrelevant evidence is not admissible. So if this is not deemed relevant, it's not going to be used in the case. So this could destroy your case. Okay, so I want you to think about that when I was kind of being maybe harsh to you, right? You might have thought I was being harsh or overly critical on kind of the word choice in the inquiry questions and the thesis statements. This is why. It has to be framed, it has to be stated in such a way that the reasoning that you're using, the support for the solution that you're going to be working on is relevant. It has to be relevant in the way that the courts have designed this. And this is also the same way that Congress thinks about things. So lots of people are very frustrated, I think, with the impeachment trial, according to what I heard in class and then what I saw in the media. But they followed the rules of evidence. And so, what I'm going to get to in a little bit is that, this is much stricter. This is a harder standard to meet. This isn't just some person's opinion. You have to be able to show that the evidence, that the support, that the information, the data you're bringing in to prove your case, to support your claim, to support your position, is that it has a tendency to make something, a fact in particular, more or less probable. So that's a causal claim. And you'll remember that I said, causation is hard to prove. And so this is why I said it. So you have to bring something that's going to make it either less likely to occur or more likely to occur. And so you have to be very careful about the relationship between the thing you're presenting as a piece of evidence and the claim you're stating about this evidence. The other thing you have to think about is that you can have something that's relevant, but if it violates the United States Constitution, if it violates a federal law, if it violates any of the other rules in the rules of evidence, or any other decision by the Supreme Court, and I gave you 2 Supreme Court cases that you're going to look at, then you cannot use it as evidence. So you've got a 2-part standard there. It has to be relevant, meaning it has to be a tendency to show a fact. And then secondly, it has to not violate one of those other things. So, you might want to make like a little checklist at home, right? So when you're putting together your evidence, you're looking for research, you find something, I think this is good evidence. You see some statistic that says, 56% of kids in such and such place are going without food. Well, does that tend to show a material fact? I'm not so sure, right? So you'd have to go deeper into that number to find out, well, what does it mean they didn't have access to food? Does that mean they don't know how to grow their food? They can't get it at a food bank? You have to be very clear about what's the relationship, because if you're saying that's a cause of poverty, well, not having access to food could be an indirect cause of poverty, but it's not going to be the direct cause. So that's not showing a material fact. So it's just you have to be very careful about the arguments that you're making, in other words. So we just looked at Rule 401, and now we're looking at Rule 701. So you can kind of see I'm jumping around, and I'm just really showing you the ones that I think are the most important. You're free to look throughout the table of contents to see if anything looks great to you and you want to do more on it. But I'm giving you, these are the basic things that I'm going to be looking for. And so this is one that I think students commonly get confused about, and I think it's largely because of television and, sadly, other teachers. Something you learn in law school pretty quickly. You have to take a class on evidence. And so what you learn is that basically lawyers are not fond, they don't like to use witnesses that are not expert professional witnesses. On TV, it's like, grandma sees the killer and then everything is solved, right? That's not realistic. First of all, grandma rarely sees the killer. Second of all, if your grandma was anything like my grandma, she couldn't see very well at all. And then third, if your grandma was anything like my grandma, she would forget what she saw 10 minutes, later. So usually witnesses are not reliable. And so if you look at the first part of this, this is why. If the witness is not an expert, they have to have an opinion that is limited to something that is rationally based. That's like 95% of human beings say things that are completely irrational. So you have to, the witness has to be someone who's a reliable person. They have to think clearly. They have to avoid superstition. They have to think rationally. And it has to be based on their direct perception. So it has to be something like, I saw this happen. I've seen it happen before. I can tell you the cause of that thing that happened, and the cause has to be rational. Even so, it still has to be helpful to clearly understanding what's going on in the case. So if it's not clearly helpful, it can be dismissed. They're not going to listen to anything that witness has to say. They're not going to get to testify. And then it cannot be based, right? They can't claim that they saw it on a TV show about science, and so now therefore a science expert. It can't be based on, well, I went to a 6-week training program, so therefore I'm an expert on fingerprints, right? This is for witnesses who have not had to go through the thorough, rigorous process of being counted and authenticated as an expert witness. If you're going to be an expert witness, and lawyers like to use these expert witnesses, by the way, they're paid. This is something that they usually have a PhD or they have a long, intensive background. For those of you who say that you want to do forensics, this is what forensics is. Forensics is the recreation of evidence in the courtroom using expert witnesses. So you'd need to have a PhD in a field, usually science, plus a good 10 years before you're going to get paid to do this work in court proceedings. And this witness is someone who's been qualified as an expert. So they usually, like I said, they have training, they have a PhD, they've done this a lot. And the point of their testimony is to show that the person who's bringing the case is going to benefit from having the expert explain parts of the facts of the case to the jury or to the judge, and that it's based on enough facts or data that this expert can talk about, that they can shed some expertise, some professional light on, and that this is based on reliable principles and methods from the field, so they have to be current. It can't be I was an expert. I mean, we have a certain professor in criminal justice at Kingsborough that likes to talk about his history and all these millions of things he couldn't possibly have done. He would never be allowed to be an expert witness in a million years. Whereas on the other hand, Dr. Chapman is an expert witness, and he stays current. He doesn't rely on his historical and things he used to do, years and years and years ago. He studies the relevant journals, right? He keeps up to date with all the relevant cases, right? He understands the principles and the methods that are used in the field at the time. That's what makes him a reliable expert witness. And then finally, the expert has to reliably apply the principles and methods to the facts of the cases while they're testifying. So usually they'll be interviewed ahead of time. This is called a deposition. And this is where the other side is going to try to attack them and say, look, like even if they know what they're talking about, even if they're relevant, even if it applies to the case, they didn't explain it correctly. And so they're not a reliable witness. And this is kind of how the game is played, right? Remember, these are the rules of the game. So just to review real quick, under Rule 701 and 702, lawyers aren't usually going to use a witness that isn't an expert. So how does this apply to your research? Well, the research findings that you get in a United Nations report are usually, almost always, going to come from people who would qualify as expert witnesses. The same thing goes for federal, state, and city local governments. Something you find on a documentary on Netflix or something, and you have to be careful, right? When the person's talking, if it says like PhD, then they might be qualified as an expert witness. If it's Joe down the street, Joe is not going to be an expert witness. Joe is going to be used as a regular witness, a non-expert witness, and then he's going to have to be rationally based by his perception, helpful and clear. He's going to have to be on a determining effective issue, and it can't be based on anything other than his day-to-day experience. So you just want to think about the reliability of witnesses. Essential, you got to have them, but you're going to have to make sure that you only include witnesses that are reliable. So this gets to, who are witnesses that are definitely not reliable. In law, we call this hearsay. So if the person says the following, I heard, he said, or she saw, no, that's all going to be hearsay. That's all stuff that the person is basing not on their own perception, but on somebody else's perception. And so it can't be like, well, I saw in a documentary, therefore I know something about it. No, bring the person who made the documentary into the courthouse. They know. They're the expert on that. Bring the person who said the thing, even better, in the documentary, and bring them and have them testify. But you can't say, well, I heard, I saw, or, he said or she said that, this is why people say he said, she said, right? You can't bring that as evidence. So you have to think about this, right? This is why I was trying to get many of you, when you're saying some other actor, right? Actor as other. No, you need to be the person. So you can interview somebody. And what I really want to hear from is I want to hear from you. What did you interpret? What did you think they were saying? Okay? So don't say they said. Say what I was hearing them say was this. Because what we're going to talk about is your recollection, your opinion. You are the expert in that case. And so I want you to think of yourself that way. Again, it's you want to kind of layer this, right? You want to have testimony or evidence that's coming in from a UN representative, for example. They're an expert. And then we want your opinion, right? Because you're the person who's going to be bringing the claim. You could start to think of yourself as a lawyer in this case, right? So you don't want to just take the word of somebody when they give you an interview. You want to say, listen, I interviewed 4 or 5 people. I looked at 12 surveys, or I looked at a survey that looked at 12 surveys, right? And this is what it meant to me. That's what we're looking for. We want the testimony come from the person directly, not indirectly. So you just have to look at these terms, and I think you can kind of figure it out, and I'll just kind of hold you to that. And so when you're offering evidence in your paper to support your position, I'm going to want to hear the source of that information, and I want to hear what you have to say about it. I don't want to hear it as well, this person said it. That's not good evidence. Rule 901 and 902, the idea is this, right? The thing cannot speak for itself. So you have to be putting the evidence into play on one of two principles. Either you're saying that this thing is what it is, and you can prove it this way. So if you say, for example, well, and I'm using an example not from this class, but from your other classes. Lots of times you'll hear somebody say, well, they had the DNA, the person's guilty. Well, what do you mean? What do you mean the person's guilty? Everybody has DNA. Yeah, but the DNA was found at the crime. Well, what do you mean? What do you mean the DNA was found at the crime site? How do you know that? Well, because they said so. Well, that's hearsay. Did you collect the DNA at the crime scene? No. So then how do we know that this DNA that you're saying was at the crime scene was ever at the crime scene? Silence, right? So police officers have a chain of custody where from the first person who collects the DNA all the way to the time it gets to the court, they have to document every single person who touches it, how it was collected, each step of the way. And if you break that chain of custody, nope, it's not getting in. So you have to think the court is very suspicious, very skeptical when people are bringing claims of evidence into a courtroom, and they want to make sure it's reliable. They want to make sure it is what you said it is, that you're not just making it up. One of the biggest defenses that ended up winning the day in the O.J. Simpson case was the fact that the bloody glove that the sheriff had said was O.J. Simpson's glove that he found at the scene of the crime, and he went to all the trouble to say that his DNA was on it, didn't fit O.J. Simpson's hand. That's reasonable doubt. That's enough to say, well, wait a second. Not just, it says reasonable doubt about 2 things, and which goes to the second thing. The first thing is that a glove that does not fit the person you say killed these people's hand is definitely not sufficient to support a finding that the item is what you said it is. You said it was O.J. Simpson's glove. The glove doesn't fit. There's no way that can be the thing you said it was. Okay? It doesn't mean O.J. Simpson didn't kill anybody. It just means that glove cannot be used as evidence to say it. But we don't know. The second part is that you said that this was O.J. Simpson's glove. We should have, we should be believing you. You're the sheriff. Why would you lie? Well, this is the problem. This seemed to suggest that the sheriff was fabricating, manufacturing, making up evidence against O.J. Simpson. And so this is not a means to assure admission. This is something that suggests something like hearsay, prejudice. I mean, there could be 4 or 5 different things that were going on here. Did somebody tell him that it was the glove? Why did he think this was the glove? Did he assume it was the glove? I mean, these are the problems that we get into the authentication. So just remember, the thing doesn't speak for itself. You find some statistic that you think, speaks for itself. No, you have to speak for it. You have to make the case. Why is this going to get in? So for your paper, just try to remember these things. Legal reasoning is much more strict than any other class, right? So when your teachers in philosophy say provide evidence, they don't mean evidence. They mean, who knows what they mean, right? But what the ones that I've talked to, what they mean is that they want to see some rational connection between the reasons why you give such and such claim, right? You say suicide should be allowed, right? You should say people should be able to commit suicide. Well, they want to see like 1, 2, 3. They want to see reasons that make sense in relationship to that claim. So if you say like everybody's life matters, and then you say people should be able to commit suicide, well, that contradicts itself. So that's not good according to their world. In this world, you have to have a medical expert saying that this number of people would benefit from having the right to commit suicide because that would be better, healthier than the alternative. In other words, they're saying something like, well, these people are going to commit suicide anyways. We'd rather have them do it with a doctor. We'd rather have them do it. That was my cat, by the way, jumping onto the whole thing of papers. But we'd rather have a doctor come in and help them than have them do it on their own. And that's the kind of standard that we're looking at when we're talking about legal reasoning that's more strict than, say, a philosophy class, and especially like an English class, right, where you're usually applying stuff from a book. And you're saying, well, this is what the person said. Well, that would be hearsay in court, right? So you'd have to somehow raise one of these fictional characters up and bring them into the courthouse and have them testify for themselves. You can see why, right? You don't have that standard in your fiction class, in your literature class, in your English class, right? And again, this is not saying like one is better than the other. I just want you to understand this is different. This is more strict. So this is why I've been kind of preparing you this way and playing these word games with you, is that this is, it's like learning a new language. So you have to be able to use the language and the standards that are used in courts. And it makes courts kind of a fun class for me, but it's, it's hard at first, right? You have to learn how to do this. So I think the easiest thing is just to start by assuming that your claim of the evidence that you're using is wrong, that it's not good enough. And then build your case, right? Say, okay, is it relevant? Why is it relevant? And show the reasons why it's relevant. Is it hearsay? Is it, as a solid piece of evidence that speaks for itself? Because if it is, then I need to make a good case for how this thing speaks for itself, how I don't need to rely on anyone else for it. Is it authentic? Can I prove that it is what it is? A lot of those statistics, right, that's hard to prove. They say 75% of such and such people do this. Well, you're going to have to show how did they come up to that number, right? Is it guessed? You'll find out a lot of the statistics are something called imputation, where they take one number and then they multiply it by a figure. Let that sink in for a second, right? So you go pay attention to your algebra class and they're giving you algebraic formulas. That's what imputation is. So they say something like, we interviewed 9 people. 7 of them said this. So there's 50 people in the room. We're going to multiply the 7 to 9 ratio to the 50. Well, maybe that's right. Maybe. But maybe not, right? So you have to, and that probably wouldn't get into court. So you'd have to prove, get those 9 people in here and don't generalize about the 50. So the point here is just try to think about the authenticity. Is this thing really what it is, or are you trying to insinuate something? Are you implying something? And then is this coming from an expert or a layperson? And you have to be able to prove it, right? So you need some citation. And then would the judge agree with you? Remember, they're skeptical, they're suspicious. So they want to make sure that they're not bringing bad evidence in. So if you're claiming that you're going to end poverty and you give 2 or 3 solutions, you got to be able to convince a judge that, the relationship is what you say it's going to be, that it's actually going to work. You're not just throwing these ideas out there and hoping they work. And then do the cases that we're going to be looking at. Do they support your reasoning? So we're not looking for content there. We're looking for the reasoning. What is the reasoning in the case of Scott v. Stanford? What is the reasoning in the case of Chevron? And so we want to see, like, how does that process work? And I'll provide more resources for you, but I'm just giving you this broad introduction. Then you're going to apply the relevant federal rules. So maybe not all of them apply, but that's what I'm looking for. Like, can you find one or two or more that apply to what you're trying to do? And this in the critical phase, right, when I'm giving you feedback on your papers after the spring break and after the midterm, you know, it'll be clear where you need to kind of be looking in the rules. And then you need to show why a judge should include your evidence for your solution, okay, to your issue or problem. So, you know, this is probably the hardest part, I think. But once you get the hang of it, it won't be hard. You'll be able to do this pretty often. And this is a good rule to use as you kind of move forward in your classes. So again, this was just a very brief introduction. I just want you to start playing around with the federal rules and getting used to them and just letting this stuff sink in. There's tons of resources on YouTube I saw. I can't vouch for how, you know, great they are. But if you need more help, I'm here, and I'll be doing another video that gets a little bit more specific once I kind of see where your thesis statements are and how your introductions start to roll around.